In the judgment before this court, which I am not going to read in details, but I'm sure the councils will have the benefit of this judgment before end of day, I have discussed what sentencing is all about in about 3 paragraphs. And my conclusion thereof is that it is the final decision of the court on the sanction which an accused person has to suffer for his acts and or omission that constitutes an offense. That you'll find discussed in one of the journals in the New Zealand, which I've quoted, the Canadian, not New Zealand, Canada, the Canadian Sentencing Commission of 1987, which simply says that is a legal sanction to be imposed on a person found guilty of an offense. A writer by the name of Rabindra Bharatani says that sentencing is a judgment of the court of law and a legitimate jurisdiction where formal declaration of legal consequences of acts or omissions of an accused person is pronounced. It is a stage at which an accused person who has been convicted, bears the legal consequences of his action. I want to draw us much more closer home in relation to the same, and you may want to look at clause 1.1.1 or our sentencing guidelines of 2023 that says that sentencing is a process by which a court imposes penal sanctions once an accused person has pleaded guilty and has been convicted. I thought it is important to put the exercise of the course sitting today in perspective by understanding that it's the last stage of the criminal trial process. The other issue I want to speak to is the importance of this particular process. Most of the time, it is an understanding that our criminal justice system starts with reading out of the charge, taking a plea on the same, trial where there's a plea of not guilty, findings of the court as to whether an accused person is guilty or not guilty, and then that's it. And very little importance is attached to the process of sentencing. And we may want to understand that is a central task in the administration of justice. And in that regard, may I refer you to clause 4.61 of the guidelines that I've just spoken to, that says that it is a central and an important process. And we'll be finding out why it's important and why it's central to the criminal justice system. In addition to the clause I've given you, may I also refer you to the case of the Attorney General versus Susan Kiguta. Is a constitutional appeal, number 3 of 2006. And just to put the point I am buttressing in perspective, let me just read 2 lines of what the court said in that matter. It said that a trial does not stop at convicting a person. The process of sentencing a person is part of the trial. This is because, and I want to lay emphasis on what I'm just about to read, because I think that is what this court was required to do, and we will be interrogating as to whether that was done. That it is a process of sentencing and is part of the trial because, 1, the court will take into account the evidence. So there is also an understanding that at the stage of sentencing, the court shuts itself to the evidence that was adduced. That is not the correct position. And so one of the factors that this court has to take into consideration is the evidence that was adduced at the trial and the basis for conviction. The other aspect and factor that the court will take into account that makes this stage to be a critical stage of the trial is the nature of the offense. So the court will have to go back and look at what is the offense that the accused person is charged with. And again, in addition, the court will have to take into account the circumstance of the case. And each case is treated on its own unique circumstances. Why are these factors important? Because at the end of the day, the question that the court must ask and answer is whether the sentence that this court will mete out in this matter today is the appropriate sentence, and more so, whether it meets the interest of justice. Please have a further reading. The case of Anton Parairo versus the State of Mahindra is an Indian case, and it speaks again to the importance of the process we are in today. And it says that sentencing is an important task in the matter of crime. And again, the reasoning for that is that at the end of the day, the court has to decide an appropriate, adequate, just, proportionate sentence that is commensurate to the offense an accused person is being charged with and convicted of. Having then looked at what sentence is and the importance thereof, let me get now back home. The case of Muratetu. We are all very familiar with the case of Muratetu. The case of Muratetu appreciates under paragraph 41 of the judgment of the Supreme Court that this is an important stage of trial. And they just use the same words and say at paragraph 41, it is evident that the trial process does not stop at convicting the accused. And the court said this: there's no doubt in our minds that sentencing is a crucial component of a trial. It therefore follows that once the court has arrived at a verdict of guilty, convicted, then the door to sentencing opens. And there are two questions that the court then will have to deal with. And the first question is, what would be the reasonable corresponding punishment for the offense? What would be the reasonable corresponding punishment for the offense? And two, whether that sentence, after it's been pronounced, was fair, appropriate enough to serve the interest of justice. In the course of the trial on sentence, general principles that guide sentencing have evolved, and I'll speak to them very briefly and make them as simple as I can. And I am laying this background because it will have a bearing on the final decision of this court in this matter, so that you have a deeper understanding where the court was operating from to arrive at the sentence that will eventually be pronounced in this matter. So the recognized principles of sentencing includes one, minimum intervention. What does it mean? It means that an accused person, a convicted person, must benefit from the less severe minimum sentence. The second principle, and for the lawyers you'll find this expounded in depth. I'm simply picking up the summary thereof. So before I go to the second principle, may I draw attention to the fact that this principle of minimum intervention is amplified and recognized in our Constitution, and I draw your attention to Article 50 of the Constitution of Kenya that says that an accused person should be given the benefit of the least severe sentence, and especially if there has been change in law in relation to that sentence between the time that accused person was charged and at the time the court is pronouncing its sentence. The second principle that we speak to is the principle of equality before the law. And what that principle speaks to is also reflected in our Constitution. And I want to draw your attention to Article 27, that in pronouncing a sentence, in meting out a sentence against an accused person, it should not be based on any of the factors stipulated under that section, which includes race, sex, color, religion, that would prejudice that accused person.